All right, so it's order approving the Fifth Amendment to the Agreement for Service. Mr. Mabry.
Thank you, Mr. Chairman. Commissioners, on May 17th, EML filed an application for approval of the Fifth Amendment to the Agreement for Service between EML and Nucor Steel Jackson Incorporated for the provision of electric service to Nucor Steel's facilities located in Flowood within EML's certificated service area in Rankin County. The execution and commission approval of the Fourth Amendment to the agreement since the execution and commission approval of the Fourth Amendment to the agreement, MISO revised Section 4.28 of its Resource Adequacy Business Practice Manual to modify certain requirements applicable to the agreement. This Fifth Amendment modifies a contractual provision to align with the requirements established by MISO in the revised Resource Adequacy Business Practice Manual. There is no change in rates. Staff recommends approval.
All right, are there any questions?
Motion approved. Second.
All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. Number 4, discussion and possible action regarding the proposed order in docket number 2022 UA 25, Yalobusha County, Mississippi, joint application of Yalobusha County, Mississippi, and the Oakland Yalobusha Natural Gas District for approval of sale to the Yalobusha County, Mississippi, of the Oakland Yalobusha Natural Gas District, including all equipment and real estate necessary to provide the natural gas service to the residents of said district, and for approval of transfer of certificate of public convenience and necessity. Mr. Mabry.
Thank you, Mr. Chairman. Commissioners, on March 16th, Yalobusha County, Mississippi, and the Oakland Yalobusha Natural Gas District filed a joint stipulation to sell and/or transfer Oakland Yalobusha Natural Gas District's gas system to Yalobusha County, and for the approval of the transfer of the accompanying certificates of public convenience and necessity to Yalobusha County. The district has 2 liens held against it by the Rural Development of the United States of America, a division of the U.S. Department of Agriculture, in the amounts of $1.2 million and $565,000. Specifically, these are from the Rural Development Community Facility Loan 9701. The Department of Agriculture has a provision for loan forgiveness that applies specifically to county ownership. With the sale of the full gas system and transfer of the accompanying CPCNs, the USDA has agreed to a reduction of the liens from $1.765 million total to $475,000, the agreed purchase price. Staff has reviewed the legality of the sale and transfer, as well as ensuring the sale and transfer complies with the requirements established for the transfer and management of debt of the system as provided by the United States Department of Agriculture, Rural Development, and finds no issues. Staff recommends approval.
Is there any questions?
Move we approve.
Second.
All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. All right, we're going to move on to the telecommunications side agenda. So number 1 is discussion and possible action regarding the proposed order in docket number 2022 UA 24, Cable South Media LLC, joint application for approval of the indirect transfer and control interest of Cable South Media 3 LLC to ITC Broadband Holdings LLC. Mr. Jones.
Mr. Chairman, Commissioners, Cable South Media was designated by the Commission a ETC back in May of 2021. Currently, they provide services in Covington, Pearl River, Lamar, Marion, Walthall, and Wilkinson counties in Mississippi. In March of this year, Cable South Media 3, Hunt Land Holdings LLC, and ITC Broadband Holdings filed this application, a joint application for approval to complete a transaction where ITC would indirectly acquire 35% voting and equity stake in Cable South, along with certain decision-making rights. This proposed transaction will result in significant infusion of capital into Cable South, which would enhance their ability to accelerate deployment of high-speed broadband and interconnected VoIP services to Mississippi customers. According to the petitioners, the proposed transaction wouldn't cause any disruption in day-to-day operation of the licensees. Also, the joint applicants state that the public interest would be served in approval of this transaction, in that they are ensure that current and future Cable South customers will continue to receive the high-quality service they receive currently. The transaction would be transparent to the customers and will enhance the overall capacity of Cable South to compete in the marketplace to provide gigabit broadband, interconnected VoIP services at competitive rates for a greater number of people in Mississippi. This transaction was filed for approval with the FCC, and the FCC approved it back on April 8th, 2022. Staff has reviewed the application, appears in order to us, and we recommend approval.
Okay, we have any questions?
Move we approve. Second.
All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. All right, now we go to the administrative agenda. Number one is discussion and possible action regarding approval of commission minutes for the May 2022 term of the commission.
Move we approve as presented. Second.
All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. Let's go to number two, discussion and possible action regarding the proposed order in docket number 2021 UA 173 Bunker Hill Water Association Order of Referral. Mr. Hammonds.
Thank you, Mr. Chairman. This is a joint application of Bunker Hill Water Association and Cedar Grove Harmony Water Association to transfer the certificate of Cedar Grove Harmony to Bunker Hill. This is an order referring it to me for hearing.
Any questions?
Move we approve. Second.
All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. All right. Number three, discussion and possible action regarding proposed order in docket number 2022 UA 041 Great River Utility Operating Company Order of Referral. Mr. Hammonds.
Thank you, Mr. Chairman. This is an application filed by Great River. In the second round of their acquisitions, they acquired a sewer utility in Forest County. After a little bit more looking, it appears a portion of that area, a entity that no longer exists and was never serving customers, had a certificate from the commission. This is a proceeding to cancel that certificate. This is referring it to me for hearing.
Okay, any questions?
Move we approve. Second.
All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. Number four, discussion and possible action regarding the proposed order in docket number 2022 UA 55 Great River Utility Operating Company LLC Order Referral. Mr. Hammonds.
Thank you, Mr. Chairman. This is a sale and transfer filed by Great River to acquire La Papillon sewer utility in Lamar County. This is an order referring it to you for hearing.
Praise Jesus.
Move we approve.
Long time coming. All right. Motion second. All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. All right. Now, number five is discussion and possible action regarding the proposed order in docket number 2021 UA 176 Entergy Mississippi LLC order affirming recommended order of the hearing examiner.
Thank you, Mr. Chairman. On October 29, 2021, Entergy Mississippi filed a petition for a CPCN seeking authorization to undertake a series of projects, transmission substation-related projects in DeSoto County. This matter was referred to Commissioner Presley. A hearing was held on May 10th with an order being entered on May 31st, 2022. Entered a recommended order of hearing examiner. The order before you is affirming and adopting the recommended order of the hearing examiner.
I got a question on that.
Wait, the order is what?
The order is affirming and adopting the recommended order of the hearing examiner.
I just,
Well, you go ahead.
Yeah.
I don't know.
Mr. Hammonds, I've been here 14 years, never had to bring an order of a hearing examiner before the commission for a reaffirmation. And I just want you to state for the record, when we assign things to a hearing examiner, which we've done zillion times since I've been here, is there not a statutory route and under rules and practice procedure and statutory route that if an item is referred to someone for a hearing examiner and a commissioner objects to that recommended order, that they have a 14-day route by which to file that objection, and we would be right here now?
That's correct, Commissioner. I'm not sure the subsection, but it's in 77-340.
Okay. So one of the great advantages that I found in 14 years of being here of having the ability to refer to a hearing officer is it cuts an unnecessary regulatory step, which allows for quicker implementation of these type of things. I've never held a hearing on any of these in which the need for the facility was in fact even contested. It's more issues related to land use, local involvement. We've had times where somebody wanted to get landscaping around a substation because of the way it looked. And I acquiesced to the idea of bringing this before the commission for a ratification. But, you know, if we're not going to follow the procedure of appointing a hearing examiner, and somebody can object if they don't like what's in that order, all three of us get them. And if somebody doesn't like what's in it and doesn't approve of it, they can object to it. Or they can, on their own, issue a letter to the executive secretary saying, I support this. But I just feel like we're going down a slippery slope to start on all of these because everybody sitting up here has had issues referred to them, some of which have impacts outside their district. But the people that are going to be served by this substation in DeSoto County are my constituents. And when their lights go out, they're not calling anybody else, they're calling me. And the issue of need, everybody has a chance to review this. And I understand I just want to put it on the record that if we're going to use the statutory route of hearing examiners, that it's my opinion that we ought to use it and use it the way the law sets up for us to use it. There is no need to come back and re-ratify something a hearing examiner has done. And so I'm fine with making a motion to reaffirm the order that I issued. But the other thing I'd like to point out is that if a hearing examiner hears an issue on, let's just say, June the 2nd, and the order is entered on June the 3rd, and June the 17th, by statute under the laws of this state, and there's no objection filed by anybody sitting up here or any intervening party, that becomes the order of the commission on June the 17th in this example. And the commission doesn't come back to vote until July. And so the effect of coming back to vote in July has no effect because the statute says that order is a legal order of the commission on the 17th. And, I want to be a team player. I want to work with everybody, but I think it's unnecessary to do some of these things and to bring them up. And everybody is invited to any hearing we hold to come on up. We'll be glad to recognize you to be there in a hearing that we hold. But, this type of unnecessary bureaucratic stuff only delays. I mean, if I'm a company sitting out there and I know that I've got a certificate that is good on the 14th day, but yet it's the practice of the agency to sit back and reaffirm. Well, what if we don't reaffirm it? What if the next month it comes in? It is just not necessary. So I'm going to play along with this game today, but I don't know that I'm going to in the future because there's a statutory way in which for this to be done and everybody to have their voice heard related to it. But it's unnecessary and it's just creating busy work for no reason.
You have a question?
No question to it, but I'll certainly try to respond to that statement. I understand your concerns and considerations and the bureaucratic malaise that you like to refer to in this situation. I understand you do reference and we do refer projects and it gets done, particularly on simple matters as transfer of ownership, CPN, and things like that. But in this case, this project did have a $37 million impact that is applied across the entire rate base. It materially impacts rates across all customers. Mm-hmm.
I don't deny that.
Well, you didn't mention that.
Well, I mentioned it.
You were talking
It
about
has a
the transfer,
$37 million
folks up
impact.
there, and I get that. But it also has a material rate impact that's going to be outlined in their T&D plan and other things that will be applied to the entire rate base. And that was my whole thought process and asking to have that reaffirmation. And I feel like it is an obligation of all of us to have a say in that vote in the application of a substantial amount of millions of dollars into the rate base. If I respect what you do in the Northern District and how you conduct yourself. I've been to your hearings and you do a fabulous job on that, no doubt about it. But just in this matter of anything beyond just a simple transfer or other activities, when you have a significant amount of money that's going to be applied across all districts, it just seems like it's incumbent on all of us to have a voice, or at least a saying on the record that affirms that the application of those dollars, the distribution of that is, just and reasonable.
Well, let me ask you this, so, I mean, you don't deny that there's a statutory route that if you objected to the order and you thought that that $37 million or that substation was needed, you have the right, you get the copy of the recommended order the hearing examiner puts out, and the law provides you 14 days in which to say, I object to what that hearing officer said, and we would be right here. We'd be right here today. And that would be that's the route that's been established in the law, and we would be here to vote on a ratification of it. But to re-ratify something that's been approved and no objection's been filed to, that's my point, Commissioner Bailey, is that we're ratifying something that no objection's been filed to, but we're re-ratifying it, and I just don't understand
I totally
why
get
that
it.
makes any
I'm not asking
sense.
to do this on every stinking one that we do out in our district. This is simply those that have a material rate impact across the districts.
Well, what do we define as material?
I mean, $37 million, that's nothing to sneeze at.
Sure, but you saw every evidence in that case, and you saw the recommended order, and you saw the testimony not only of the company and the recommendations of the staffs and other, and there's a 14-day period in which one could very simply write an email to Ms. Collier and say, I object to the recommended order, and we'd be on this agenda with that today. And I'm not trying to belabor it, I've just been here 14 years, and I've never in any of these cases seen us have to come back and re-ratify what a hearing examiner went and did in their district. I understand the amount of money, I understand every bit of that. I could argue that lots of cases that we refer out have impacts, whether they be in our district or not, but have impacts statewide, especially when we have subsidiaries of others that are doing things. And I'm not trying to be obstinate about this. I just, I think it's important to understand that there's a statutory route for everybody to have their voice heard on. That's all.
All right, so I'm gonna jump in here real quick. Yeah. So look, this seems more like a procedural issue.
Correct.
So you have a procedure. So from now on, if you have this problem, just get with Ross. We'll follow that procedure.
I move we approve the order I issued.
I'll second your motion.
All in favor, signify by saying aye.
Aye.
Any opposed? Ayes have it. All right. Number 6, discussion and possible action regarding the proposed order and docket number 2018 AD 141, Mississippi Public Service Commission Omnibus Docket. Order designated hearing examiner related to underground facilities damage prevention board. Mr. Hammonds.
Thank you, Mr. Chairman. The order before you comes kind of at the request and with some work with the Underground Facilities Damage Prevention Board. I think kind of dating back to the 2016 timeframe, the Commission's Pipeline Safety Division statutory is required to provide administrative, investigative, and legal support for that board. When that board went and promulgated rules, they implemented a provision that gives them the ability to call on state agency attorneys to serve as hearing examiners for purposes of entities that are disputing civil penalties. The order before you right now simply refers those types of matters to Stephanie Taylor in perpetuity. So whenever that board comes to us needing a hearing examiner, we'll have something in place to authorize her to do that.
Okay. Has anybody got any questions?
I just asked a question, back on this hearing examiner issue. Are we gonna have to come back and reaffirm, how's that gonna work?
So the provisions of that are found in the Underground Facilities Damage Prevention Board's rules. They have provisions in there that once that recommended order that Stephanie, that Ms. Taylor will issue, that becomes a recommended order of that committee.
Gotcha.
That decision will come back.
So it don't come back to us.
That's correct.
I move we approve.
Second.
All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. Number 7, discussion and possible action regarding the proposed order, commission investigation into acts done or omitted to be done by L&F Water Association, order establishing docket and referring matter for hearing. Mr. Hammonds.
Thank you, Mr. Chairman. The order before you is establishing an investigative docket for L&F Water Association, which is located in the Central District. The order authorizes the refers it to Commissioner Bailey and authorizes him to investigate quality of service concerns in that area.
Move we approve.
Second. All in favor signify by saying aye.
Aye.
Any opposed? Ayes have it. Is there any other business before the commission?
Got one thing, Mr. Chairman. As you know, if you saw the news in the last week, President Biden has nominated Bill Rennick of Ashland to serve on the TVA board. I've just asked, unless there's objection from the bench, that the staff, widely praised nomination by Senator Wicker and Senator Hyde-Smith, completely across the aisle. This nomination gives Mississippi a seat on the TVA board for the first time in a good while. And I just asked, I'm not putting this in form of a motion, but just asked the staff to prepare a resolution for consideration by the commissioners between now and the July meeting of support for Mr. Rennick's nomination that we could forward to the Senate. And that's just a request. Thank you, sir.
All right, do you got anything? Nope. All right, I got one thing. I want to acknowledge the executive director of the public utility staff on her last day here, and let you know on behalf of us, and the commissioners can talk about it, how much I appreciate the support and help that you and your staff have given, especially your leadership and always being available to help. And we wish you luck over at the broadband office. You'll do well there, and I'm very proud of you for having to come from the Senate to here and learn all this and then jump into that mess. So good luck, and we love you. We appreciate you.
Thank you very much, Commissioners.
Thank you.
All right, if there's no other business, then we're going to stand in recess for 5 minutes and reconvene for a hearing. All right, we're going to reconvene and begin the hearing agenda before the commission. Docket number 2018 UN 205, Notice of Intent of Entergy Mississippi Incorporated to implement revisions to the formula rate plan. We'll start with entries of appearance. We'll recognize attorneys for the commission.
Thank you, Mr. Chairman. Ross Hammonds for the Mississippi Public Service Commission.
Public utility staff.
Emily Kruger for the staff.
Sam Mabry for the staff.
Okay. Entergy Mississippi.
Good morning, Commissioners. Tiana Raby, along with co-counsel Alicia Hall and Alexander Martin for Entergy Mississippi.
Okay, and Rankin County, Mississippi.
Good morning, Michael Wolf on behalf of Rankin County.
Okay. All right, thank you. I understand someone from the staff is going to present a joint stipulation.
That's correct, Commissioner, I will.
Okay.
Thank you, Mr. Chairman. Commissioners, can y'all hear me? All right, can y'all hear me now? Thank you, Mr. Chairman. Commissioners, on March 1st, 2022, Entergy Mississippi filed its annual formula rate plan, FRP7 evaluation report for the 12 months ending December 31st, 2022. FRP7 requires EML to make an annual filing for the current year, along with a look-back filing of the 12 months ended December 31st, 2021. In the 2021 look-back filing, the company filed for an interim adjustment of $34.5 million. Staff made certain adjustments to EML's look-back filing, which resulted in a reduced revenue requirement of $34.1 million. The 2022 evaluation report indicated that an increase of $69 million for the 2022 test year was necessary. However, due to the 4% limit on revenue adjustments, the company is requesting a revenue adjustment of approximately $48.6 million. You will recall in the April billing cycle, the company implemented a temporary rate that was capped at $24.3 million, or 2% of total revenues. After staff's review on June 1st, the company and staff entered into a joint stipulation regarding EML's March 1st filing, where the staff and company agreed that EML's filing complies with the parameters of its filed tariff subject to the disallowances I noted earlier for certain O&M expenses from the company. As part of the stipulation, staff and EML also agreed to adjustments to EML's 2022 evaluation report. Those adjustments will be reflected and included in the look back for the 2022 test year and in subsequent filings, but are not implicated here due to the 4% cap on revenue adjustments. The joint stipulation results in a final stipulated revenue requirement of approximately $34.1 million in the look back and $48.6 million in the 2022 evaluation report, subject to adjustments in the next filing. This results in an increase of $3.13 per month for a 1,000 kilowatt hour residential customer that will be applied to the billing months of July 2022 through June 2023. Entergy Mississippi has also implemented a fully costed customer charge in compliance with the Commission's directive in docket 2021-8019. Staff has reviewed the company's calculations of the customer charge and confirmed that the customer charge aligns with the general principles of retail cost allocation. It is important to note that this change in customer charge is revenue neutral for the company, meaning Entergy Mississippi will not receive any additional revenue as a result of the change in the customer charge. Rather, it is an issue of cost allocation, and for a typical 1,000 kilowatt hour customer, the change will result in a decrease in rates. Staff has reviewed the company's calculations of the customer charge, and the overall rate increase from Schedule FRP7 would be $5.90 without the change in customer charge. Staff is satisfied the amounts as stipulated are a fair and reasonable representation of the company's revenue requirement. Staff recommends approval of the joint stipulation between staff and the company.
Thank you. We're going to recess for a second here. Figure out what's going on. Okay, we're gonna get started again. Energy, at this time, we're gonna swear your witnesses in and hear testimony. So Madam Court Reporter, can you swear the witnesses?
Robin Jeter.
Shannon Cruz. Crystal Elba. Katrina Huddy. You swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? Yes.
Okay.
Good morning, Commissioners. Mr. Mabry has shared with the Commission that the staff and Entergy Mississippi have filed a joint stipulation for your review and approval. And so importantly, what I wanted to do is just to express to the Commission and others that the stipulation is the culmination of a multi-year annual cost review, which is an 8-month-long process during which the Commission and the staff review Entergy Mississippi's submission to redetermine its rates for each year. And so as this relates to the matter before you today, Commissioners, the formal process of this year's FRP began in November 2021 when Entergy Mississippi filed its transmission and delivery plan, the T&D plan, explaining the major capital projects that Entergy Mississippi planned for 2022. At that point, the staff and its consultants began their review of the T&D plan. On March of this year, Entergy Mississippi filed the evaluation report, which included testimony, highlights of which you will hear today, providing an overview of the submittal and explaining the significant portions of the filing. On March 15th, Entergy Mississippi submitted to the staff complete work papers supporting the FRP filing. Entergy Mississippi also provided its responses to the staff's first set of data requests, which was a compilation of 91 questions. Along with this March 15th submission, Entergy Mississippi included an attachment I, which is essentially an update to the T&D plan, and further lays out capital projects with the cost exceeding $1 million, and those are the plans for 2022. And what followed is a continuation of the transparent process, and the staff reviews Entergy Mississippi's entire submission to determine the reasonableness of the company's expenses, capital accounts, which is its rate base, revenues, and operational performance. The staff also propounded additional discovery requests to Entergy Mississippi regarding its submittal. The staff and its consultants sent additional data requests about the T&D plan and attachment I. And so as you can see from this process, it is a transparent process, one of which a review of everything that Entergy Mississippi provided was conducted. Accordingly, I'd like to present Entergy Mississippi's witnesses who will provide the commissions with a high-level overview of their testimony. I do have a preliminary matter, however. Commissioners, we have the issue of moving some of the exhibits into the record. I do know that there are several items from the docket that we would like to do so, and I'd like to provide counsel for Rankin County an itemization of those documents.
That's fine, go ahead.
I've submitted electronic versions of those to all counsel of record, but I wanted to make sure that he had that in hand. And so what we'd like to have entered into evidence is first, as Exhibit 1, Entergy Mississippi's 2022 FRP submittal, which includes the company's November 1st, 2021 submittal of the transmission and distribution plan, its March 1st and 15th submittal of the formula rate plan filing and the work papers accompanying the March 15th submittal, the company's energy and delivery plan filed in docket 2019 UA 232, and the reports from staff consultants Bates Whites on the T&D plan and energy delivery plan. We'd like that to be marked as Composite Exhibit 1 and received into evidence. The next thing is that Entergy Mississippi and the staff have entered the joint stipulation for your review and approval, and we'd like for that public version to be marked as Exhibit 2 and received into evidence. As Composite Exhibit 3, we'd like the data requests propounded by the staff and the company's responses to be entered into evidence. As Exhibit 4, we'd like the filings related to Rankin County's intervention, several documents and pleadings to be entered into evidence as Composite Exhibit 4. As Exhibit 5, we'd like to offer into evidence Composite Exhibit, which includes the data requests between Entergy Mississippi and Rankin County, both those that Entergy Mississippi propounded to Rankin County and those that Rankin County propounded on Entergy Mississippi, and of course the responses. As one final preliminary matter, Commissioners, Entergy Mississippi filed pre-filed testimony for 4 witnesses, and that was Robin Jeter, Alan Hurd, Shannon Cruz, and Crystal Elba. However, Mr. Hurd is unable to participate in today's hearing for medical reasons. I've consulted with counsel of record, and they have no objection for Mr. Jeter, Ms. Cruz, and an additional witness, Ms. Katrina Hutty, to adopt Mr. Hurd's testimony as appropriate. It doesn't change the substance of his testimony. We just have different witnesses addressing those topics in Mr. Hurd's testimony. And so I have a chart that each counsel of record has received electronically that I would like to be marked as Exhibit 6, and that itemizes the portions of the testimony from Mr. Hurd that each witness is adopting. Without any objection, I'd like that those items be moved into the record as evidence.
You're good.
So, Commissioners, I would like to present each of the witnesses for Entergy Mississippi in a panel, and then once they have completed adopting their testimony as appropriate, and then also providing a highlight of their testimony, tendering them for any questions.
Before you do that, let me say that I'm gonna ask you hold all your questions until all the witnesses have testified. And then I'll call back on you to ask your questions. Y'all may proceed.
Thank you, Commissioner. Mr. Jeter, can you please state your name for the commission?
Robin Jeter.
And you pre-filed written direct testimony in this docket, is that correct?
That is correct.
And if I were to ask you today the same questions that are contained in your pre-filed testimony, would your answer be the same?
They would.
Do you now adopt your pre-filed testimony as your testimony today?
I do.
Have you reviewed Mr. Hurd's pre-filed testimony that Entergy Mississippi filed with its March 1st, 2022 FRP submittal?
I have.
And in his absence, are you adopting portions of Mr. Hurd's testimony as identified in the chart marked as Exhibit 6?
I am.
Could you please provide an overview of Entergy Mississippi's FRP filing, including the portion of testimony you're adopting from Mr. Hurd?
I can. Good morning, Commissioners.
Good morning.
My name is Robin Jeter. I'm the Vice President of Reliability for Entergy Mississippi. I'm the company's lead witness in this proceeding and submitted pre-filed direct testimony. With me at the table are other witnesses who filed direct testimony in this proceeding. Ms. Shannon Cruz is the Project Coordinator, Regulatory Filings. Ms. Crystal Elb is the Manager, Regulatory Compliance. And Ms. Katrina Hutty, who is the Manager, Regulatory Affairs, is present today as well and is adopting portions of the pre-filed testimony of Mr. Alan Hurd, who's unavailable to participate in today's hearing. Entergy Mississippi remains committed to safe and reliable utility operations with a focus on customer service and reasonable prices, and continuing to make capital improvements proactively to meet customer service expectations and satisfy the company's obligation to serve its customers. By the end of 2022, EML will have spent approximately $2.9 billion on its infrastructure since the company's rate modernization plan was approved in 2014, a 70% increase. During that same time period, a typical residential customer's bill has risen by only 9%, while the cost of other goods have increased much more. For example, the cost of bread and eggs has risen more than 35% in that same time period. Entergy Mississippi is requesting approval of a joint stipulation that provides for a rate increase pursuant to the formula rate plan, which this commission has utilized for many years and permits rate adjustments, both decreases and increases. The joint stipulation is a result of consistent, reasonable regulatory oversight by the commission and provides for the necessary rate increases to permit Entergy Mississippi's financial condition to remain sound. The joint stipulation reflects the extensive review that the staff conducted of Entergy Mississippi's FRP submittal, as well as its annual transmission and distribution plan. The company also responded to over 150 data requests from staff. The stipulation provides for an interim rating adjustment that increases revenues. The main driver of that interim revenue increase or that the 2021 look-back reflects actual 2021 revenue, which was lower than anticipated when rates were set, and Entergy Mississippi's 2021 infrastructure improvements. The joint stipulation further provides for an annual rate adjustment. The company expects to make nearly $400 million in infrastructure improvements in 2022. These improvements that we are making to meet customers' expectations and satisfy the obligation to serve are the main driver of the annual revenue increase. As I described in my testimony, infrastructure improvements have increased reliability and resiliency and supported economic development. Despite these revenue increases, our rates will remain reasonable and will encourage economic development. With these rate actions, the typical residential price per kilowatt hour still compares favorably to the 2021 U.S. and Mississippi average residential price per kilowatt hour. For these reasons, we request that the Commission approve the joint stipulation.
Okay. You got any questions? You? Okay.
Thank you. Thank you, Mr. Jeter. Ms. Cruz, can you please state your full name?
Shannon Cruz.
And you also filed testimony, written direct testimony.
Yes.
And if I were to ask you today the same questions that are contained in your pre-filed testimony, would your answers be the same?
Yes.
Was there an exhibit to your testimony that you filed?
Yes.
And was that drafted or created by you or under your direct supervision?
Yes, it was.
Is that exhibit accurate and correct?
Yes.
Do you now adopt your pre-filed testimony as your testimony today?
Yes.
Have you reviewed Mr. Hurd's pre-filed testimony?
Yes, I have.
And are you adopting portions of Mr. Hurd's testimony as identified in the chart marked as Exhibit 6?
Yes.
Are there any changes to the testimony that Mr. Hurd submitted?
Yes.
Can you please identify that change?
On page 12, line 8, the testimony says 22.6 million, but the figures should be 24.3 million.
Other than that correction, are there any other changes to Mr. Hurd's testimony?
No.
Are you now adopting those portions of Mr. Hurd's testimony as identified in that chart?
Yes.
Please provide a summary of your pre-filed testimony as well as the testimony you're adopting from Mr. Hurd.
Good morning, Commissioners. My name is Shannon Cruz, and I am a project coordinator within the Regulatory Filings Group. I coordinate the preparation of the FRP submittal look-back and evaluation reports. I submitted direct testimony to support the company's 2022 FRP submittal. Additionally, I am adopting certain portions of the direct testimony of Alan Hurd as detailed in the designation chart provided to the Commission. I'm here today to summarize the results and drivers of this year's FRP. My summary reflects the results of a stipulation that the company has entered into with the public utilities staff. Working with subject matter experts across the company, I oversaw the compilation of the financial data for the 2021 look-back and 2022 evaluation report. The company's 2021 look-back is based on per-book financial information from the books and records of the company as of December 31st, 2021, with certain adjustments. The company's 2022 evaluation report begins with a 2021 look-back, but also includes known and measurable adjustments. In those adjustments, the company requests recovery of the COVID-19 deferral. Last year, the Commission found that the company's calculation of the COVID-19 deferral was consistent with the Commission's deferral order. Also, those adjustments reflect recovery of demand-side management program expenditures. Turning to matters which I am adopting in Mr. Hurd's testimony, FRP 7 sets forth a formula for adjusting the company's rates based on its revenues, costs, and its performance. The Commission-approved formula protects both the company and customers and allows for rate increases and rate decreases. The 2021 look-back shows that the company's revenue was not sufficient for the company to reach last year's point of adjustment approved by the Commission with last year's 2021 evaluation report, due in large part to FRP 7's 4% rate cap. FRP 7 provides for an interim rate adjustment, increasing revenues by $34.3 million on an interim basis. The 2022 evaluation report reflects that the company is continuing to make investments for the benefit of customers. It also reflects cost decreases, such as a favorable financing activity undertaken by the company, which will save customers over $12 million on an annual basis. Taking all of this into consideration, the 2022 evaluation report shows the need for a rate adjustment of $71 million. But FRP 7's 4% rate cap limits the company to a revenue change of $48.6 million, beginning in July 2022. The company's 2021 look back and 2022 evaluation reports were prepared consistent with FRP 7's provisions and have been subject to a thorough review by the staff.
Okay, is there any questions? Okay, next witness.
Thank you, Ms. Cruz. Ms. Elba, can you please state your full name for the commission?
Crystal Elba.
And you pre-filed written direct testimony in this docket, correct? If I were to ask you today the same questions that are contained in your testimony, your pre-filed direct testimony, would your answers be the same?
Yes.
Were there exhibits to your pre-filed testimony?
Yes.
Are those exhibits accurate and correct?
Yes.
Do you now adopt your pre-file, are there any changes or updates to your pre-filed testimony?
No.
Do you now adopt your pre-filed testimony as your testimony here today?
I do.
Can you please provide the commission with a summary of your testimony?
Good morning, Commissioners. My name is Crystal Elba. I am the Manager, Utility Pricing and Analysis under the Regulatory Services Organization. I submitted direct testimony supporting the company's March 2022 FRP submittal, where I explained the company's incorporation of a fully costed fixed customer charge as part of the 2022 evaluation report. The purpose of the customer charge is to ensure the utility recovers customer-related costs that are incurred without regard to the demand on the company's capacity or the amount of energy consumed by the customer. The cost of meters, meter-related expenses, and bill preparation expenses are examples of customer-related costs. In January 2022, this commission directed Entergy Mississippi to include a fully costed customer charge in its next annual FRP filing. The commission approved Entergy Mississippi's revisions to Schedule FRP 7 in the March 2022 FRP submittal. EML included revised residential and general service rate schedules, as well as related riders, to incorporate a fully costed customer charge. The proposed customer charges and rate design are based on the company's most recent cost of service study. The results of EML's unit cost study, which is part of the cost of service, show that to recover the residential rate classes customer-related costs through a monthly fixed customer charge, the monthly residential customer charge should be set at $14.68 per customer. The results further show that to recover the general service rate classes customer-related cost through a monthly fixed customer charge, the monthly general service customer charge should be set at $28.38 per customer. The company designed the increases in customer charges to collect the same level of revenues as before the proposed rate changes. To do that, the proposed customer charge increases are offset by volumetric charge decreases in the residential and general service rate schedules. Thus, when applied to the most recently approved billing determinants, the two sets of changes result in EML collecting the same level of base revenues as approved in the last rate case. Entergy Mississippi and the Mississippi Public Utility staff have agreed to a joint stipulation on EML's 2022 FRP submittal, agreeing that the proposed residential and general service rate schedules should be approved as filed.
Thank you, Ms. Elba.
You may proceed.
Ms. Huddy, can you please state your full name and job title?
My name is Katrina S. Huddy. I'm the Manager of Regulatory Affairs for Entergy Mississippi.
And what are your principal responsibilities as Manager for Regulatory Affairs?
I am responsible for coordinating EML's filings with the Commission and for coordinating regulatory activities in conjunction with rate design, rate administration, and cost of service information.
Ms. Huddy, Entergy Mississippi, as you know, filed the 2022 FRP submittal on March 1st, 2022, and subsequently supplemented that on March 15th, 2022. Are you aware of those filings?
Yes.
Did you file pre-filed direct testimony in this proceeding?
No.
Have you reviewed the pre-filed testimony of Alan Hurd that was filed with the March 1st, 2022 submittal?
Yes, I have. I have read the direct testimony of Alan Hurd filed in this docket, and I am familiar with the facts stated in his testimony.
Are you here today to adopt portions of Mr. Hurd's testimony that's indicated in the chart we provided the commission?
Yes, I'm adopting portions of Mr. Hurd's testimony today because Mr. Hurd is unable to be present for medical reasons.
And which portions of Mr. Hurd's testimony are you adopting?
I'm adopting questions 20 and 21, which relate to the bill impact of the 2022 forward test year and 2021 look-back reports.
If I were to ask you today the same questions that are in Mr. Hurd's pre-filed direct testimony, would your answers be the same as Mr. Hurd's?
Yes,
And do you now adopt those portions of Mr. Hurd's pre-filed testimony as your testimony here today?
yes.
Can you provide a summary of that testimony?
My testimony covers the bill impact for the initial net adjustments effective April 2022 and the bill impact for the revenue changes effective July 2022. Combined with the initial rate adjustments and implemented consistent with the provisions of scheduled FRP in April 2022, the total impact of the 2022 evaluation report will be $3.12, or 2.62%. The July 2022 residential bill will be approximately $122.16. After incorporating the fully costed customer charge as part of the 2022 evaluation report and including the temporary effects of the percentage of base rate schedules, the approved stipulation would result in an increase of $1.39, or 1.15% compared to April 22 for the monthly bill for EML's typical residential customer using 1,000 kilowatt hours.
Thank you, Ms. Huddy. Commissioners, based on the evidence in the record, including the testimony that you've heard today, Entergy Mississippi respectfully requests that the commission approve the joint stipulation submitted by Entergy Mississippi and the public utility staff. I tender the witnesses.
Okay. Any questions from you guys?
Just, one, I'm not sure who mentioned this in that, but talking about the COVID bad debt deferment, what was the total that was, that's gonna be, I guess, deferred over the next 36 months as part of this?
The total is 13.1 million.
13.1 million?
Yes.
Is that deemed to potentially grow further, or is Entergy doing everything they can to, I guess, rectify that as expediently as possible?
That balance will not grow as far as I understand.
One question, and this is just kind of a constant on this, because we keep using this 1,000 kilowatt hour typical customer. And we hear the impacts that is, who can testify as to what your typical customer actually uses?
I can.
Okay,
So if we use the 1250 kilowatt hour, the impact to that customer would be about $2.34, or 1.61%.
okay. Well, that's kind of my question is, though, if you look at all your, I guess, 400,000+ customers and look at your residential and average it, is that where we're coming up with this 1,000? I've been arguing about this 1,000 for a long time. How do we get to 1,000?
So Commissioner, if I may, the 1,000 typical kilowatt hour customer is something that's the industry standard. And so what Ms. Huddy is actually providing is what we've determined is the typical customer for the average residential customer.
And so
for
that's
Entergy Mississippi,
1,250.
And that's the 1,250. So that's the information she was providing for Entergy Mississippi. But for comparison and industry standard purposes, we still do report the 1,000 kilowatt hour customer.
Okay. Thank you. That's the only question I have.
Okay. Thank you, Ms. Raby. Now, Mr. Wolf, on behalf of Rankin County, do you have any questions?
I do, thank you. I think my first question might be addressed to Ms. Jeter, but as to any of my questions as a panel, please feel free to respond. Regarding the 4%, I think Ms. Cruz testified to the 4% of limit there. Do you agree that the stipulation describes that as the amount of the increase shall not exceed 4% of the company's unadjusted evaluation period revenue? Would that be accurate?
Yes.
And what goes into this unadjusted revenue?
Unadjusted revenue is just per book revenue. It ties to the trial balance and also the FERC Form 1.
All right, does it include unbilled revenues?
No, unbilled revenue is removed from our filings.
Now, does the IRS require reporting on unbilled revenues for the payment of taxes on unbilled revenues?
Objection.
Sustained.
And under generally accepted accounting principles, do you report to shareholders in the statements unbilled revenues as part of the total revenue for a particular year?
Objection.
Sustained.
Would you agree that a decrease in the revenues occurred during this evaluation period by removing the unbilled revenues?
I would need to look at the adjustment again. But
Well, I'm sorry, go ahead.
I believe the removal of unbilled actually increased our revenue.
Well, did it result in a higher increase requested on the look back by not having the unbilled revenues?
Objection. Ambiguous question. If you understand, you can answer.
I was going to ask for clarification.
Now, just so we're clear on this, the stipulations and according to testimony talk about a unadjusted evaluation period revenue, but without unbilled revenue, it is in fact an adjusted revenue, correct?
We're talking about our 4% cap unadjusted.
Yes.
So I'd need to refer to the schedule to make sure that I'm saying the correct amount for.
Well, you see, the question though is, it is in fact an adjusted rather than an unadjusted number that you're using, correct?
No, we're using our per book amount.
All right. Now, in order to work around this unbilled revenue or exclusion of unbilled revenue, y'all has cited, or the stipulation cites at paragraph 12, cause number 2014 UN 132 as some sort of precedent, correct?
Objection. So, Mr. Wolf, I think the issues that you're bringing up are really the issues that we were determined to have not been part of the subject matter of this hearing today, and specifically with respect to the questions and the issues that you're bringing up right now about the unbilled revenue. Our witnesses are here to talk about what was in our FRP submittal and the direct testimony contained therein. And so these other issues that I think you've gotten direction on to not address within this hearing because it's out scope of this hearing, I think are inappropriate.
If I might respond.
Sustained. Also, when you object, if you would, just explain
I will do so.
better.
Mr. Chairman, I got a question. So is it the company's position that, Mr. Wolf, you cited adjusted and unadjusted, and you cited that from where?
The FRP 7 requires that, and this is from the stipulation, page 2, paragraph 2, it states that FRP provision that for each annual evaluation period, the amount of each revenue shall not exceed 4% of the company's unadjusted evaluation period revenue.
Is that found in the statute?
I believe that's in the FRP. I believe that's, and I'm not familiar with this particular statute that it might come from, but I.
Well, it's in the declaration of policy where they set out a formulary rate plan, but that's not in the statute.
No.
I'm not arguing with the point you're making. I understand where you come from. I'm just trying to understand where you pull that.
Yeah, I'm not familiar with the particular 4% statute, but I am reading the FRP 7 provision that it limits to 4%. With regard to the prior objection, may I respond to that?
Yes, sir.
Yeah, I believe that the suggestion that I've been limited to some sort of testimony that they've just, for not examining on testimony that they've just offered, I think is inconsistent with the ideas of cross-examination. If they're putting into evidence and asking for stipulations and to be accepted, I think I'm entitled to inquire regarding the basis of those stipulations.
Okay.
But if I may, Commission, one of the things that is very apparent is that the pre-filed testimony that you received highlights of was not just received today, either by the Commission or Mr. Wolf. Secondly, the issue with respect to what is in the stipulation and what is in their pre-filed testimony is distinct with respect to some of the things that he's bringing up about issues that he raised that are outside the scope of the FRP. With respect to their free file testimony and unbilled revenue, Ms. Cruz answered the question, and that is the subject matter of her pre-file testimony. The other items that he's citing to do not go to the issues that are before this commission and are outside the scope of the FRP.
I'll give Mr. Hammonds a minute to respond.
Thank you, Mr. Chairman. For purposes of the record, I want to highlight a couple things. Pursuant to the statute, pre-hearing conference was held in this proceeding. Rankin County has obviously filed a motion to intervene. They have filed a motion to stay these proceedings. And in both of those documents, there are a lot of allegations made. There's a lot of conclusory statements. There's a lot of speculation. There's a lot of stuff in there. There is not one cite. There is no evidence in any of those documents. At the pre-hearing conferences, Rankin County was given the ability or an opportunity to file pre-filed testimony in this proceeding. At this point, none of that is in the docket right now. None of that is in the record. So and again, Mr. Wolf does make a point that, pursuant to Mississippi rules of evidence, which to note the commission is not bound by. Certainly on cross-examination, you can go outside the scope of what is in the pre-filed testimony or in the record. I think for purposes of Rankin County's having the chance to offer that pre-filed testimony and supporting evidence for a lot of what is the underlying, again, allegations, speculative things, right? I would just advise the commission that I think while we could go outside that scope a little bit, that leash be a little short. I'll leave it at that.
So, having said that, and you recommend keeping it short.
I would recommend, I think from where we just kind of left, I think where we left it was Rankin County had asked a question, there was an objection. So I think for purposes of right now, I think Rankin County could restate their question and us just pick it up there.
All right.
I can do that.
Well, the issue, and I'm not, the definition of accounted, adjusted and unadjusted, we do have to figure out, as to what that relates to. So if the company's going to object to Mr. Wolf asking, I'll just ask it myself. And they can object to me asking it. But we've got to get to a point that we understand what that is, and that's central to what's in it. And I don't understand how, I'm not trying to belabor this, but I'm saying that's central to how you get to a figure that triggers where we're here. And I don't see any harm in trying to define as to what we actually are, whether that dollar figure, adjusted or unadjusted, based upon the procedure, triggers the things that we're talking about.
Yeah, I would agree with that. That's why I think if Mr. Wolf could restate his question and pick it up. I just thought at this juncture in the hearing, it was important to get that on the record.
Okay, that's fine. I'm just trying to get us a little clarity on that.
And so if I may, Commissioner,
Yeah.
we're not objecting to describing or explaining what unbilled and what unadjusted and adjusted figures are in the FRP filing. Absolutely, we don't object to that. But what we do object to is for Ms. Cruz to be asked about the policies regarding the decision, and she's only able to talk about the methodology that we use to calculate that and to provide the numbers. But any policy decisions or how we're handling that based on the guidance from the commission is outside the purview of her testimony. And so we can go ahead and allow her to answer the questions to the extent you think they're appropriate.
We'll let him ask his question.
In the stipulation offered by the staff and Entergy at paragraph 12, it references accepting a lack of, well, it doesn't use these words, but it talks about approving a joint stipulation in June of 2016 on docket number 2014 UN 132 and subsequent FRP approval orders. Would you agree, Entergy, and any one of you can agree to this, that such stipulations are understood and expressly agreed that they're made for the purposes of those proceedings only and shall not apply or be used as precedent in any other proceeding of Entergy Mississippi or any other utility?
Objection. You've changed your question now, Mr. Wolf, and those are legal conclusions. And so please understand that this joint stipulation, portions of which were drafted by attorneys for the parties, do have legal conclusions, and issues of legal precedent are not the proper purview for this witness. She's here to testify about the adjusted or unadjusted or any of the other factual determinations that went into the FRP. But policy considerations about how the rules are interpreted, how the orders and opinions of this commission are interpreted, neither of my witnesses are attorneys in this matter.
Mr. Chairman, I'd recommend sustaining that objection.
Well, the question was different, so I will sustain it. And let's move on.
I'll go back to the other one. With regard to adjusted or unadjusted, would you agree, anybody from Energy, would you agree that the revenues looked at during this period are actually adjusted and not unadjusted?
The revenues looked at? Is that the?
The revenues used in your application today are actually adjusted and not unadjusted.
Yes, we make adjustments to our per book revenues.
And so that's inconsistent with FRP 7 provision, correct?
No, the provisions allow for adjustments.
All right. And $4 of the unadjusted valuation period, where in the FRP is it allowed that you can exclude unbilled income?
The 4% cap is on unadjusted revenues, so that is our total per book revenues. When we move to the results of our calculation, we remove unbilled, and so that would be an adjustment made to our per book revenues.
So it is adjusted.
What is it?
The revenues that you're using to calculate this request.
The revenues used to calculate our rate adjustment have been adjusted. The revenues used to determine the 4% rate cap are unadjusted.
Now, the change in the FRP revenues pursuant to the 2021 look back, you indicate in the stipulation are $34,341,547. That's paragraph 3, page 3. What is included in that number?
What is included in 34.3 million?
Yes.
The result of the calculation for our 2021 look-back filing, which includes our historical test year of 2021 with certain adjustments.
Right, and the base rate was included in that, correct? Or the rate base, correct, was included in that?
Yes.
All right. And explain how you calculated the rate base.
The rate base is calculated using an averaging method, depending on the function of the plan accounts. So for example, production and transmission accounts would use a 13-month average. And then distribution, general plant would use a beginning-ending average.
All right, so you used a 13-month average, and during that 13-month period, was the Choctaw generating unit included in the calculations for all of 21?
Yes.
All right. And in the look back for revenue requirements, was that, let me strike that. And how much was that number of the, that was included for the Choctaw generating unit for all of 21?
I don't have that information.
Now, in the stipulation of last year of June of 21, it was indicated that the FRP rate of $59.1 million was a transfer from the interim capacity rate. Correct?
I'm not sure where we're referring to.
Can you direct her to what you're speaking to in the stipulation?
It's regarding the June 21st stipulation in this cause. There was a transfer from interim capacity rates of $59.1 million. You don't disagree with that, and that relates to the Choctaw generating unit. You don't disagree with that, do you?
Well, I would
Commissioner,
like to-
what document? Are you referencing last year's
Yeah, the June of 21
I don't-
stipulation.
He's referencing.
So the stipulation for June of 2021 is not at issue here. That is something that has already been approved by this commission and become commission policy, specifically with respect to that interim capacity mechanism. So our witnesses are here to talk about the FRP that was submitted in March of 2022 and the approval of the June 2022 stipulation. We can talk about possibly, and I hope that that will occur, but the June 2021 stipulation is not something that we're here to testify about.
I think the fact that there's a $59.1 million point of revenue, I can follow up with another question.
Do that.
What month periods was that 13-month period calculated? From when to when?
For our 2021 look
The one-
back,
The ones you're looking at here in this pleading here.
it would be December 20 through December 2021.
Okay. And June of 21 was within that period, correct?
Yes,
And in June of 21, you requested a $59.1 million transfer from interim capacity rate, correct?
Objection. Although the June 2021 stipulation was, the time, you're confusing the time periods that these things took place with their applicability to a particular FRP, Mr. Wolf. And so even though the look back for 2022 encompasses the 2021 months, it does not encompass the matters that were dealt in our 2021 FRP.
So I'm going to sustain it, and I'm going to ask you to stay within the realm of what we're here to talk about today, and don't reach out.
And I will say this, we do not want to hide the ball from the commission or Mr.
I'm going to
Wolf.
object to the argument.
We've asked for documents and the basis of some of these allegations so that we could be prepared in good faith to answer some of the questions that you would raise. But we don't have our witnesses committing to memory everything that we did in a prior filing.
Now, let me ask the next question. Did Entergy represent that last year's 59.1 million would not have an incremental effect on rates? You know? That represent last year that there would be no incremental effect in that June of last year's stipulation?
If anybody knows the answer to that question, you can answer.
According to the testimony of Alan Hurd, there was an agreement that the FRP was capped at 4% of the company's unadjusted evaluation period revenue. Do you agree with that testimony from Mr. Hurd?
Objection, we've asked and answered that, but go ahead.
And you agree that it was reduced by unbilled revenues, correct?
when we say it, what are we referring to?
The evaluation period revenues.
The per book evaluation revenues were adjusted to remove unbilled revenue to arrive at a total adjusted revenue amount.
Now, are you not in fact exceeding that amount by asking for an additional $34 million under this 2001 filing when you consider the $44 million in June of 21?
Objection. Can you, Mr. Wolf, the stipulation for 2021, asking questions, and I'm going to object every time you ask about the joint stipulation for 2021. The joint stipulation for 2021 does not have applicability for the perspective, from the perspective of these witnesses of having to commit everything to memory. If they know the answer, they may be able to answer to the extent it applies to our FRP today. But asking about calculations that were done that went into that stipulation are not before this commission today.
Except that you testified that 13-month period includes that June of last year. So we're looking back over that same period of time, coming up with revenues, and between that was spent then and that which was being asked for now, would you not agree that you're over $77 million?
But the thing, if I may objection, that 13-month average is reflected in the data that we submitted to the commission in March 2022. It is not the data that is in the joint stipulation for June 2021.
So I'm going to sustain both those objections, and I'm going to say, if you continue to do that, if you know it, answer it. Otherwise, don't answer.
All right, I'll move to a different topic. All right, in Mr. Hurd's testimony, and I don't know which of you would address this, but he discusses the cost of capital at page 6 of his testimony. Could any of you explain how the cost of common equity was calculated?
The cost of equity was calculated consistent with the provisions of the FRP, which uses an average of a discounted cash flow method and a regression analysis.
All right, and how did you determine the ratio of common equity to total capital?
The ratio of common equity total capital?
Correct.
Well, you would look at the amount of long-term debt that we have and the calculation of our total capital amount and the equity portion of that.
Now, did you include contributions from Entergy Holding to Entergy Mississippi during the 2021 as equity or debt?
Not that I am aware of.
Is anybody aware of whether it was treated as equity or debt? And are any of you aware that over the last 3 years, that 75% of Entergy Holdings' capital has come from incremental debt?
Objection. We are here testifying on behalf of Entergy Mississippi
Sustain.
and the data that we have submitted on behalf of Entergy Mississippi.
Mr. Chairman, if I might say something, Mr. Wolf, if you have any evidence alleging the imprudency of a cap structure, again, you were given an opportunity to file pre-filed testimony and supporting evidence and chose not to.
Well, yeah, I believe we're entitled to some leeway in asking questions to explore, and as the commission does, to explore the veracity of the information that is provided, whether we offer any or not.
But we provided information on behalf of Entergy Mississippi. So for you to ask about information on behalf for Entergy Holdings is outside the scope of even what you've delineated as appropriate.
The objection's sustained, so let's move forward.
All right. I have no further questions.
Okay. Mr. Hammonds, do you have any?
No questions, Mr. Chairman.
All right. All right, thank you, Mr. Wolf. Anybody else have any questions for the witness?
Is it our time?
Yeah.
All right. I got some questions, and I understand for the Council for Entergy where they're coming from, but I also want to recognize and just put on the record that Rankin County is represented in a county in this state, and they're 81 of 82. And while some of these questions, I understand where it comes from. So if y'all want to object to me asking them, have at it. So first thing I want to know is on FRP 7, to the definition of adjusted and unadjusted, is that language included in the formulary rate plan FRP 7? Who can answer that? Well, you can't testify because you're counsel, so you got 4 witnesses.
Do we have the tariff in our binder?
We can get the tariff.
Is that, my question is, to be clear, is the words accounted and unaccounted for in the 4% calculation included in the FRP 7 language?
So Commissioner, are you saying accounted for or unadjusted and adjusted?
Adjusted
Okay.
and unadjusted, my apologies.
Okay, okay.
Adjusted and
So,
unadjusted.
all right.
Now, who knows that?
I would like to refer to the tariff for confirmation, but my understanding is that yes, it is.
Okay. Are you familiar with Code Section 7733, paragraph 2, subsection C, item 2, in which it says a hearing shall be required as provided by law to determine compliance with the formula rate plan. I'm reading you from the code. And the accuracy of the data prior to any change in level of revenues if the accumulated change in any calendar year exceeds a greater of $200,000 or 4% of the annual revenues of the utility. And I want to highlight for the record that first sentence. A hearing shall be required, we're here today, as provided by law, doing it lawfully, to determine compliance with the formula rate plan. And if the formula rate plan designates adjusted and unadjusted, then that is central to what we're doing. And so somebody can answer the question as to adjusted and unadjusted and the impact that has on this. And I understand the company's objections, but quite frankly, I mean, I think it's a silly point because you understand as well as I understand that's central to what is in the plan.
But Commissioner, if I may, she did answer about how we calculated both the adjusted and unadjusted in the
Well,
fund.
I couldn't get that because y'all objected to every question that came along. So you can restate that for the record then.
Okay. Unadjusted revenue is our per-book revenue, which ties to our trial balance. It also ties to our FERC Form 1. We then make adjustments to our per-book revenue, one of which is the removal of unbilled revenue, to arrive at adjusted revenues, which is then used in our rate determination formula.
Okay, that's fine, and I understand you. I just want to be clear what the statute actually says as to what we're doing here today. And y'all set these, I've never liked formula rate plans since the day I walked in this building. And I don't like them today. But they're what's in place. And if we're going to follow the law, it's unfair and it's wrong, in my opinion, for monopoly corporations not to answer simple questions that go to the heart of practical parts of the rate plan they're here to be testifying about that the statute requires. And so that's my question on that. Now, my other question is, you referenced $13.1 million in written off COVID expense. Is that correct, $13.1 million?
That is the amount of bad debt, COVID-related expenses that
Okay.
we have deferred.
And Commissioner Bailey asked a very pertinent question as to what you're doing to try to mitigate that $13.1 million. Because we know that included in the American Rescue Plan Act and others that there were increases for a lot of allocation to Mississippi related to LIHEAP, Low-Income Home Energy Assistance Program. I'd just like to understand, and you can file this as a late filed exhibit. In fact, I'll make it in the form of a request as to what efforts have been made by the company to work with the community action agencies to try to whittle down that $13.1 million because my understanding is Mississippi Power wrote off their COVID-19 debt. And I don't know, are y'all writing any off in this?
So,
We're requesting recovery of our deferral.
Okay, but you're requesting recovery of the full deferral?
Yes, the $13.1 million.
Okay,
but
that's my question.
Commissioner, based on the guidance that we received from the commission, we did work with our customers to provide them access and resources to get access to some of that aid so that they could, be able to pay those bills. And then that number that we are asking for is less than the amount that was previously accrued. And so the 13.1, I think what Ms. Cruz testified to is that 13.1 is the final result after the commission advised us that we should stop deferring that amount.
Yeah, and I'm not saying, I want to be very clear, I'm not at all being critical of the way in which you've gone about that. I think that all our utilities during that time did a wonderful job, and I think have done the best they can. I just would like to understand, though, we're putting $13.1 million into rates for that last amount that was unrecovered, and I just want to understand whether the company has had any activity dealing with community action agencies, of which my office deals with on a daily basis, to try to get access to people in LIHEAP funds that may have a bad debt with the company, because those funds can be applied to prior debt accrued. And I'm not at all being critical about what y'all have done with it. I appreciate the fact I know personally of folks that you've tried to put on payment plans to try to help. I just want to understand, Are we trying to access the funds that are out there that could pay some of that down? Just a simple.
Commissioner, we do work with those outside agencies as best we can.
On bad
We can
debt?
follow up. LIHEAP dollars, et cetera, that you described.
Right, but I'm talking
I'm
about-
not answering the bad debt issue, but certainly, you know, we're very active in that space with Salvation Army and others in terms of helping customers with their payments.
And then this is just the last question, if, unless you don't agree with this statement, feel free to say it. The commission's not bound to adopt a stipulation. All four witnesses understand that, correct? Okay, thank you, Mr. Chairman.
Yeah, just a couple more. Things.
Yep.
All right. So just looking at the storm impact dollars that you've dealt with over the last few years. So there are expenditures in 2020 of $70.1 million in storm impact. In 2021, expenditures of $78 million, but budgeted $18 million. This year, 2022, your forecast are budgeting $13.3 million, but already we've seen, you know, the forecast to be higher than expected, an above normal storm season, particularly in hurricanes and that kind of stuff. Is budgeting low and expecting expenditures high down the road and having to come back, is that the best way of handling that type of storm recovery process going forward? Is it? I'm just wondering.
I think it's a great question, and I would love to tell you I know exactly what's going to happen the rest of the summer, and I'm not being flippant about that. Obviously, the way we budget impacts how many dollars we have available to invest in the infrastructure, et cetera, and I think your point's well taken, and we should certainly take it under advisement that storm costs have been rising over the last few years.
And just one more, and this is probably more of a statement than anything else, so don't flag me down here if I get too far out of bounds. But I know we're here for the FRP 7 and the review of that, but we certainly know the impacts of the increase, the rapid increase of price of natural gases have, and we took action earlier in the year to amortize a $100 million fuel balance over 2 years. I just want to encourage you guys to do everything you can to work as hard as you can and come up with all solution aspects as we continue to see where natural gas is today and what that means in the cost recovery aspect that you guys are dealing with, and how to have as minimal impact as possible for customers over this next planning cycle.
Commissioner, we really appreciate that sentiment, because you're right, it impacts customer bills at the end of the day, which has a tremendous impact on what our customers can afford and for us to invest in the infrastructure, provide a better quality of service. So we absolutely agree and understand, work very hard on that.
All right. Ms. Kruger, you have anything?
I don't.
Okay. Commissioner, I'm gonna let him. All right, Entergy, are you good? You need to redirect or anything? Okay.
I move we take the case under advisement. I said I move we take it under advisement.
I'll second that motion.
All in favor signify by saying aye.
Aye.
Any opposed? All right, well, I have another hearing after this, so seeing nothing else before the commission, we stand adjourned.